The district court provided the state with parameters, outlined what an appropriate remedial map looks like. They even provided the General Assembly an example. Why did the majority party feel a need to draw just a whole nother map altogether?
Well, so the remedy that Judge Jones gave us, he used examples of, he used an example from the Pendergrass case that he felt was an appropriate location for this new majority black district to be located. And we drew the map to comply with that, and that's what we've done.
Further follow-up, Mr. Chair. So why, I heard you talk about District GA 13, and that shifted, you said, to the east. So why is it that the current GA 07 split up between 13 and 4 in this map?
Well, anytime that you draw a new district, you apply those traditional redistricting principles, and there's a ripple effect that happens. After you draw one district, you've got to accommodate for the population surrounding that district. So that's why those districts changed.
One last follow-up. I heard you talk about the opportunity districts and that you guys did not eliminate them. However, did the attorney provide any advice to you about protecting the coalition districts?
So Judge Jones said that
I
need.
don't know that we should ask her to disclose anything that her attorney said to her. I mean, that seems to impact attorney-client privilege, but to the extent there's been any public discussion about that, I mean, the lady can answer the question.
Well, we just complied with what Judge Jones said to do.
Thank you.
Thank you, Representative Alexander. Chief Deputy Whip Scott.
Thank you. Thank you, Mr. Chairman. How exactly does this map abide by the court's order?
So Judge Jones told us to draw a new majority black district in, I'll quote it, on page 509, he said, the remedy involves an additional majority black congressional district in West Metro Atlanta, and that's what we did.
Okay, follow up. Okay, in his 516-page order, Judge Jones orders more than just an additional majority black congressional district in West Metro Atlanta. Can you name any other aspects of Judge Jones's order that this map complies with?
Well, in the remedy portion of his order that's found on page 509, that's where he tells us what he wants us to do. And that's what we've done. That's what I quoted just a second ago. The remedy involves an additional majority black congressional district in West Metro Atlanta.
Okay, another follow-up. Okay, Judge Jones's order specifically says, I'm going to read starting from page 509, the state cannot remedy the Section 2 violation described herein by eliminating minority opportunity districts elsewhere in the plan. So the Republican eliminates a minority opportunity district, Georgia 07, Representative Lucy Macbeth's district. In an area not named in the decision, Georgia 07 goes from 67% minority voting population to 33% minority voting population. How is this map not a violation of the judge's decision?
Okay, so this plan, I disagree with you respectfully. This plan does not eliminate any existing minority opportunity districts. As I stated earlier, Judge Jones was clear on 510 that we cannot eliminate those existing minority opportunity districts, but he doesn't define that term. He clearly is referring to existing majority black districts, but he never says that specifically. So we've complied because we did not eliminate any majority black districts.
Okay, follow up. The 11th U.S. Circuit Court of Appeals ruled in the 1990 case concerned citizens of Hardy County versus the Hardy Board of Commissioners that minority coalitions are protected from having their votes diluted. They specifically said the 11th Circuit, citing Campos and Midland without elaboration, found that two minority groups may be a single Section 2 minority if they can establish what they behave in a politically cohesive manner. So why do you disagree with the existing case law from the 11th Circuit Court?
Okay, so I think you're talking about some introductory language in that concerned citizens case. In the three-judge panel opinion issued in the Georgia NAACP versus State of Georgia case on October 26, 2023, the judges said this about the 11th Circuit's language in the concerned citizens case, and I'll quote, "Thus, the court's assertion about coalition districts was dicta. Whatever judicial opinions say, judicial decisions cannot make law beyond the facts of the cases in which those decisions are announced. For those of us that are non-lawyers, that means it's a statement that is not binding in lower courts." So to be clear, Judge Jones joined that opinion, which was issued on the same day in the Section 2 cases that brought us here to where we are in special session. So there's no binding case law from the 11th Circuit on the question of coalition districts.
Okay, and my last one. Is partisan gerrymandering a traditional redistricting value or principle adopted by the committee? If not, why does the majority party's map ignore traditional redistricting principles such as compactness to maintain a gerrymandered political majority?
Does the chair lady want to answer that, or?
I don't believe we've participated in political gerrymandering.
No, I'm done.
Those are good answers too. I think we've got